Hello again, I'm attorney Robert Flessas, and thanks for watching this video. I've posted a number of videos on debt buyers on my channel. Well, here's another one. If you decide to challenge the case, you'll tell that to the judge at your first court appearance. Or if you're only required to file a written answer, then you'll make that decision clear in writing in your answer. But first, if you like my videos and find them to be informative and helpful to you, then please consider subscribing. Why is that important to me? When you subscribe, it's telling me that you want to see more videos. If I see more subscribers, then I'll take the time to produce even more videos that help you. Let's get to the topic of this video. You should take notice of any exhibits that are attached to the complaint that was served on you. In most cases, the only exhibit that's attached to the complaint is a copy of a statement from the original creditor that sold the debt to the debt buyer showing the balance due. Sometimes more exhibits are attached. Each collection attorney sets up their complaints differently depending on what information they receive from their client. So to prepare for court, which is going to be a mini trial to challenge the lawsuit, you should be doing all of the following. If the attached exhibit is only a statement showing the balance due, then that proves nothing. Did you sign a contract with the original creditor? Where is it? How did they come up with this balance? Let's see the math. How did the debt buyer purchase the debt? Let's see the assignment of the debt. Do you really owe the debt buyer anything? These are some very logical and simple questions, right? The debt buyer's attorney has to prove their case, not you. Make them prove it. The debt buyer's attorney can't rely on just the statement that's attached as an exhibit or the words written in their complaint to prove their case. So a recent question I got from a Texas viewer was, if I only have the exhibit that shows the balance, how do I get more documents from the attorney? Well, first, if they can't even produce any more documents beyond the original creditor statement, then you may want to move the court to dismiss the case. They've not proved that you owe the debt and that you owe it to the debt buyer. You can ask the debt buyer's attorney if they'll be providing you with any more documents. And if they say yes, tell the attorney that you'd like them to either give them to you while at your first court appearance, if that applies, or if you weren't required to appear at an initial hearing and only had to file a written answer, then tell the debt buyer's attorney that you would like the attorney to send the documents to you. I'd follow up with a letter to the attorney, even though they told you that, after your verbal request. Sending the letter by certified mail is the best way to do it because you have proof that you mailed it to the attorney. The post office will give you a small green and white receipt that's stamped with a date in red ink. Don't lose this receipt. It's evidence that you sent the request. Today, I'm going to tell you about affidavits that the buyer may present as evidence. If they're giving you affidavits as part of your request, look at them this way. An affidavit is a sworn statement that's notarized. That's all it is. Somebody, called the affiant, is providing information as to the transaction. This document is attempting to prove that the original creditor sold the debt to the debt buyer, and now the debt buyer has the right to sue you. Here's how you look at an affidavit. First, you'll want to identify the person who signed the affidavit. Also, what was their role in the transaction? Most likely, there are three possibilities of the affiant's role. The affiant could be an employee of the original creditor. That person's going to state they have personal knowledge of the transaction. They'll probably state in the affidavit that the debt was sold to the debt buyer. But here's the problem with that one. Did they conduct the transaction themselves between their company and the debt buyer? Is their signature on a document called the assignment of the debt to the debt buyer? Do they even have that document to show you? Or is this affiant merely reciting what happened in the transaction? If so, that could be hearsay. Where is the original person who transacted the sale? Or who had the authority to make the sale to the debt buyer? If that person does not have personal and direct knowledge of the sale of the debt to the debt buyer, then you could object to that affidavit. You would say, Judge, the affidavit and the person that's making the statement does not have personal and direct knowledge of the transaction. Therefore, the affidavit is not the best evidence, and therefore the court should place no credibility on the affidavit, and the affidavit should not be allowed as evidence regarding the sale of the debt. The second person who could be making a statement in an affidavit could be an employee of the debt buyer. Since the debt buyer company is purchasing thousands and thousands of debts from creditors, they would also have to have direct and personal knowledge of that debt being purchased. The debt buyer company will have to dig deep into their paperwork of hundreds of thousands of purchases to find yours. They're probably all on a computer today, right? But that still may not work. If they're making statements on behalf of the creditor who sold the debt, that's not good enough either, because that comes under the evidentiary rule of hearsay. They can't say what somebody else said. They can't speak for the original creditor. The third type of person that could be making a statement in an affidavit would be an employee of the law firm that's representing the debt buyer. That won't fly. That person's affidavit is worthless. Under the hearsay rule, that person can't speak to the sale. They can't make statements on behalf of the creditor or the debt buyer. Therefore, their affidavit is of no value and should be disregarded by the court. So affidavits can be challenged, but you need to read them carefully and think about what they're trying to accomplish. They're trying to take a shortcut to prove their case. Remember, every jurisdiction has different rules when it comes to defending debt buyer lawsuits. Sometimes it's not a bad idea to come in early to an initial court hearing on debt buyer lawsuits to see how the court handles them in your state. I'd like to hear your story. Let me know what state and city you're from and which debt buyer is suing you. There's a bunch of them. Tell me what documents they attach to their complaint. Remember, I can't give you legal advice, but your stories may cause me to make another video that talks about your specific issue. There are more documents that the debt buyer's attorney can present as evidence. That'll be discussed in another video. I'm attorney Robert Flessas. Thanks for watching, and please subscribe. We'll see you again.